So yes, I will be discussing migraine in the workplace, legal protections for employees. A little bit about AIMED Alliance. We're a nonprofit that seeks to protect and enhance the rights of healthcare consumers and providers. So quick preview, I'm going to give a few statistics on migraine in the workplace. I'll discuss federal protections, including the Americans with Disabilities Act and the Family Medical Leave Act. I'll go over potential benefits under short-term and long-term disability policies, and then we'll end by going over Social Security disability insurance. So migraine in the workplace. Employers do have a vested interest in the health and well-being of their employees. They want to be able to show up and be productive. It's really in their best interest to create a welcoming environment for employees with migraine, including by offering sufficient benefits. Migraine impacts individuals during the majority of their working career, as we saw earlier, most commonly between the ages of 25 and 55. And yet during a migraine episode, more than 90% report being unable to work or function normally, and 51% report that their productivity level is cut in half. Migraine is also results in significant financial loss for the employer. So it's really important for those employers to take steps to offer accommodations to mitigate the onset of an episode and offer benefits to assist employees when they experience episodes, because they are such valuable workers. So going over the ADA, of course, not all employers do offer comprehensive benefits. However, even so, individuals with migraine may be protected under certain federal laws. So first is the ADA, the Americans with Disabilities Act. And this is a federal law that protects against discrimination in the workplace, among other things. So it applies to employers, state and local governments, employment agencies, and labor unions. And the key is that they have to have 15 or more employees for this law to apply to them. These agencies cannot discriminate in the hiring or the firing process. And it's important to note that not everyone with migraine disease will be considered to have a disability, because disability is determined on a case-by-case basis rather than based on a list of conditions. But as you will see, most likely a lot of individuals with chronic migraine likely would qualify. So under the ADA, employees must both be a qualified individual and have a disability. Disability is defined as an impairment that substantially limits one or more major life activity, such as caring for oneself or working. Other ones include eating, sleeping, walking, standing, lifting, concentrating, reading, a lot of thinking. A lot of these are impacted by migraine. An individual is considered qualified if he or she is capable of performing the essential duties of the job, and the key is with or without accommodation. So if the employer determines that you can't meet those essential duties without accommodation, they could still decide not to hire or fire you. And essential duties are the tasks that are fundamental to a position. So ancillary duties don't count. If you think about it this way, for a secretary, for example, or administrative assistant, answering phones might be an essential duty, but standing might not. However, employers do have a lot of leeway in determining what is considered essential. And even if you have a disability, your employer can still decide not to hire or fire you in certain circumstances. And that includes, as I mentioned, failing to meet the definition of qualified individual. Also, if you pose a direct threat to the health or safety of yourself or others, or if the reason for hiring or firing is completely unrelated to disability. And direct threat is defined as a significant risk of substantial harm that cannot be eliminated or reduced by reasonable accommodation. So if you think of somebody who is a truck driver and they frequently get migraine with aura, their vision is going to be impaired, and so they may pose a direct threat to the safety of themselves or others. There are some things that employers are also not permitted to do, although there are exceptions there too. So they're not supposed to make a disability related inquiry or require a medical examination as part of the job application or as part of the job, unless those inquiries or the examination is shown to be job related and consistent with business necessity. So the employer can require medical examination or that inquiry only after the job offer is made and before the applicant begins work in those instances. And the employer can also make a conditional offer of employment on based on the results of the examination or inquiry if all other employees in the same job category are subject to that same examination and require and inquiry regardless of what the disability is. So they have to treat everybody the same. They can't single you out because you have migraine. Employees can and should request reasonable accommodation, which is a modification or adjustment to the work environment. And accommodations must be provided to qualified individuals unless doing so would cause an undue hardship for the employer. An accommodation is considered undue hardship if it causes significant difficulty or expense to the business, but the majority of accommodations cost less than $500. So for most employers, that makes them reasonable and pretty easy to implement. So you're going to see, as we see from this list, many need reasonable accommodations both during migraine or to limit triggers, and those include light, sound, and scent, as we've heard about. Examples of accommodations include alternative lighting, anti-glare filters or fluorescent lights, noise canceling headphones, anti-fragrance policies, flexible schedule, ability to telecommute. Employees must request the accommodation. They can't just expect that the employer will implement them. And it's really important to document everything, especially if you feel like you're being treated unfairly, your accommodation requests are being ignored. Essentially, what you need to do is build your case just in case you have to file a complaint or sue. Also, your employer may require you to present a doctor's note when you do request those reasonable accommodations. Migraine as a disability, as I mentioned, not everyone with migraine is going to be considered having a disability. However, 90% of individuals with migraine cannot function normally during an episode. And it does impact those major life functions, such as sitting, standing, seeing for hours. This is a case I wanted to quickly go over. It's one in which the court found that this individual did not have a disability, and I think it's telling because I think the employee didn't present his case in the right way, and you'll see what I mean by that. So this employee worked as a sales rep. Migraine episodes left him temporarily incapacitated, which impaired his ability to work and other life activities as well generally. Around the same time, he started to receive poor performance reviews, but he also just really wanted to move to Asia. So he submitted a doctor's note stating that the employee's migraine disease could result in serious health consequences, work-related stress or was a trigger, and that absent change in a current environment, medical leave of absence alone would not significantly migrate his stress. So his requested accommodation was to be permitted to perform the same job, but under different supervision in Asia. Essentially wanted to move there. The company declined his request, and following subsequent poor performance review and written warning, they fired him. He did sue for discrimination under the ADA, but the court ruled that his inability to perform a single particular job did not constitute a substantial limitation in major life activity of working. Rather, he needed to show that his condition precluded him from working in a class or a broad range of jobs. Now, he could have presented his issue as limiting other major life activities. But because he admitted that he could do the same job so long as he was under different supervision, the court ruled that he did not have a disability in the major life activity of working. I think the takeaway here is that court is not always going to find migraine as a disability. And also it's really important to be reasonable when you're requesting your accommodation, because that's not, that type of accommodation is not likely to be seen as something that's considered, or it is considered undue hardship on the employer. I think this individual could have requested something a little bit more reasonable, such as working from home. And I think he easily could have established that migraine for him was a disability. Also, regarding denial of accommodation, if your accommodation is denied, you want to ask why and whether the accommodation requested was unreasonable, and then try and work with your employer to come up with some sort of middle ground. Maybe you guys can come up with something together that works for both of you. If you're denied for unknown reasons, go up your chain of command, talk to your supervisor, talk to your HR professional, talk to your CEO, whoever you can, whoever you're comfortable speaking with. And then be sure to document all of your interactions. You want the dates, the details of the conversation, who was saying what. If it's unsuccessful and you're not able to get that accommodation, you can file a complaint with the Equal Employment Opportunity Commission, which is a federal agency, or with your state's enforcement agency. And if the EEOC dismisses your charge, you can file a lawsuit against your employer. Moving on to the Family and Medical Leave Act. So this is another law that can offer you some protection. It guarantees employees the right to take unpaid leave for certain urgent situations, including when you're dealing with a serious health condition or you're caring for a family member with a serious health condition. So if somebody in your family has migraine and you want to take care of them, you can still use family and medical leave. This provides 12 weeks of unpaid leave over a 12-month period. And that leave doesn't have to be consecutive, so you don't have to take it all back to back. You take days here and there. It also guarantees that while you're out on that leave, that your employer, if it's required to offer health insurance, continues to offering that health insurance during your leave of absence. And employers are not allowed to interfere with, restrain, or deny the exercise of any right guaranteed under the FMLA. So qualifications under this, your employer has to have 50 or more employees. You have to have worked 12 months within the previous 7 years. You also have to have worked 1,250 hours during a 12-month period. And your employee and you have to have worked at a site that has 50 employees, or where your employer had 50 employees within a 75-mile radius. To request leave and protect your health benefits, you have to provide your employer with adequate notice. So typically, this means at least 30 days in advance, unless the situation is an emergency. And you must submit medical certification from your healthcare provider if your leave is due to serious health conditions such as migraine. If your employer has retaliated against you because you took time off, and you provided that proper notice of requested leave, you gave them the certification, you did everything right, you can file a complaint with the Wage and Hours Division of the Department of Labor, DOL, or you can sue your employer directly. You have 2 years to file that lawsuit. I wanted to go over short-term and long-term disability. Many employers do offer these types of policies. However, if they don't, you can also always purchase a policy through an agent if your employer doesn't offer it. Short-term disability is typically offered for a 90-day period, but policies really can vary, and they can range anywhere from 30 days to a year. You should be aware that short-term disability plans do have a requirement for how many days you need to be out of work before you can claim disability, and that's called an elimination period. And essentially the reason for this is that they don't want you to invoke that short-term disability for something that could be covered by your sick days. Long-term disability starts after you've exhausted your short-term plan. So there may be a waiting period of 3 to 26 weeks, taking into account the typical short-term disability policy length and time. Long-term disability typically covers a period of 2, 5, or 10 years, or until you reach the age of 65 or 67, depending on the plan. However, that plan may also require you to sign up for Social Security Disability Insurance, SSDI. And oftentimes they will help you enroll for SSDI, which is great. Another thing to note is that the definition of disability will vary. It's defined by the policy. However, usually it's a condition that renders you unable to do your job. You will usually receive a percentage of your salary. Most commonly it's 50 to 70% with a certain dollar amount cap. So it might be a little bit lower depending on what your salary is. And your employer may offer its own internal policies, which may be set up a different way. You'll also need to submit paperwork here to utilize your disability benefits. And the paperwork required will depend on the terms of your policy. So they may require medical records, a note from your doctor, and oftentimes with long-term disability, updates after your doctor's visits. Some individuals have difficulties utilizing disability benefits because migraine sometimes isn't easy to diagnose, as we heard earlier. And you will need to prove that migraine limits your ability to work. For that reason, it's very important to document everything in a detailed migraine journal, including dates, all of your symptoms, which dates you had migraine episodes, and how they impact your ability to work. And you can also gather in supporting documentation from your doctor, and that includes your medical records. The more written evidence you have to support your claim, the better. And then make sure all your medical records are complete and up to date. So it should include those doctor's notes about frequency, intensity, severity, results of tests, medications and treatments that you tried and whether they were effective or whether you failed on them, and records of ER visits or hospitalization. And then have clear documentation of how many hours and days of work you missed due to migraine. And then lastly, I wanted to really quickly touch upon Social Security disability. So this benefit typically awards $15,000 per year, but there are several criteria that you need to meet to receive it. You have to show you are unable to work and earn a gainful living. And you or your family member must have paid or had a recent job and paid into the program. You also have to prove that that you have a medically determinable impairment. That's a medical condition that might last at least, or that will last at least a year, or might result in death and limits your ability to be employed. And then you have to provide evidence of the severity of that condition. Again, using the same kind of evidence I just mentioned for your short-term and long-term disability plans. You'll have to demonstrate your level of impairment. Typically, this is done by showing that your condition is equal to a condition that is in the Blue Book. This is a list of conditions that SSDI or that the Social Security Administration has. Currently, migraine, unfortunately, is not in the book. The closest condition is epilepsy. And those with migraine have had a harder time getting approved for disability and retaining benefits, but luckily it is getting easier due to a lot of advocacy work that was done last year. The Social Security Administration recently released guidance specifically on migraine and how to obtain SSDI. And then of course, if you're denied, you want to appeal those findings. You can keep appealing. So this is the policy or the guidance that Social Security Administration released last year. This is just a short clip from it. So the document is called Chronic Migraines and Social Security Disability, Applying for Social Security Disability Benefits with Migraine. If you want more information, I highly recommend looking up that title. And you can see that they've given you some clear-cut guidance on things that you'll want to submit to them and evidence you want to provide in order to qualify for SSDI. So this is really helpful. And then lastly, I just wanted to share that we have additional resources through AIMED Alliance. We have a brochure called Women with Migraine Disease, Addressing Discrimination in Your Workplace, and Migraine Patients Know Your Rights. And this will go over a lot of the things that I addressed today. So highly recommend taking a look at those. Our website is aimedalliance.org. And then this is my contact information if anybody would like to get a hold of me with any questions that you may have. Thank you.
Thank you so much, Stacey. We do have a few questions for you that we'll just take really quickly. One is, currently has an FMLA applied for a new position and was offered the job at the same company. Do I need to inform my new supervisor, or does HR?
So it's the same company, is that correct?
Yes, it sounds like it's the same company, just a new position.
Okay, so then, yeah, you should be fine as long as you've already been approved, you've submitted all the proper paperwork. I don't think it hurts to talk to your new supervisor if you're comfortable doing so, but I don't think that it's required.
Okay. Do you need to tell a prospective employer that you have migraine?
No, you definitely don't. If you want an accommodation and you feel comfortable asking, then you'll want to tell your employer or prospective employer. But that's really a decision that's up to you and your comfort level.
One of the questions that I had personally, actually, when I was dealing with this was, what's the best way to document our conversations with employers? Because when things would get kind of dicey with me, they would tend to call me on the phone, so it couldn't be documented through email. Do you have a way, a good tip to get around this?
Yeah, so there's two things you could do. As soon as you get off the phone, make notes of everything that was said during that conversation. Or if you feel comfortable doing this, it might be a little tricky, but you could summarize the conversation in an email and send it to your employer saying, from my understanding, just to recap our conversation, this is what was said. I'm not sure if that will create more conflict for you, so you might be better off just making your own notes, but that is an option.
Okay, good to know. When applying for a new job, at what point do you need to disclose needing accommodations and having a disability?
You can wait until after you receive the job. You definitely do not need to disclose any of that to your potential employers. And then once you have the job, you can request the accommodation, but it's not required ahead of time.
Do you have a recommendation if it's better to tell your boss directly, or if it's better to go directly to HR on that?
It again, it really depends on your comfort level. You could
Okay.
do either, but whoever you feel more comfortable talking to. So, and whoever you think will be more understanding. Also, it also could depend on your employer's internal policies. Perhaps in some workplaces they want you to go to your HR professional, and others they want you to start with your employer. I would recommend asking if they have a policy on accommodations before you have the conversation, because then you can get a sense of what their policy looks like and if they have their own instructions on what you should do.
Okay, would this also apply to needing accommodations such as lighting and fragrance? Just bring it up with who you're most comfortable with, or? Okay. Good to know. I think that's all of our questions. We're a little bit behind, but our speakers were wonderful today. We thank you all so much for your time. I certainly learned a lot. We just want to thank all of our amazing